Want to welcome everyone to Cyber Week. It's the 23rd year that we've been hosting this about online dispute resolution, free international online conference. We thank everyone for getting up early and staying up late so we can have a wonderful international engagement. I am Leah Wing, and I'm the co-director of the National Center for Technology and Dispute Resolution. And I'm going to share the screen now and give you a sense of the context for this, this webinar today. This is part of a series that is based on the book, the new ODR Treatise on Online Dispute Resolution Theory and Practice. And it's one of the authors' panels focused on ODR impact on practice areas. And we've got a wonderful panel. We're going to speak about ODR and ombudsing, ODR and negotiation, ODR and mediation. And I'm going to turn it over in a moment to the moderator, Dan Ramey, who's going to talk about how the panel is going to run. But I wanted to let you know that you can get a copy of the book for your library if you're in the university setting, or for yourself as a practitioner or student. And I'll be putting the information about how you can get the 40% discount in the chat in a moment. And just a reminder, this is the beginning of Cyber Week. We've got 3 or 4 activities every single day this entire week. And one of those events each day is an author's panel, and we hope you will join us for some of the other ones. So welcome, and I turn it over to Dan now. Thank you.
Thank you, Leah. As Leah said, this is the first panel of the week that focuses on chapters in the book that we recently published. What we tried to do, the editors, and there were 3 of us, Mohammed, Abdul Wahab, Ethan Cash, and I, what we tried to do was to think about what the major issues are that we face when we're trying to deal with technology and dispute resolution, and not so much look ahead, although we try to do that a little bit, as dangerous as that is when you talk about technology, but to say, okay, where are we and what should we be thinking about, and what are the things that we've learned over the last 2 decades that would help us when we operate online. And Leah, I cannot believe this is the 23rd year of Cyber Week. When you said that, it sort of took me back for a moment. And so as we go through the week, what we're going to try to do is focus on various aspects of online dispute resolution, broadly writ, the application of information and communication technology to the practice of dispute resolution in really all the forms that we can think of, from peace building down to ombudsmanship, negotiation, and mediation, which is where we start out the week. What we're going to do is have 3 separate short presentations. We're going to go in what I think is a reasonably rational order. We're going to start with mediation. Noam Ebner is going to talk a little bit about the chapter that he and I wrote on mediation. We're going to move from that into the chapter on negotiation with Michael Wolf. And then finally, Claire and Frank and Herb are going to talk to us about ombudsmanship and the use of technology in ombudsmanship, 3 major practice areas. And one of the reasons that I was particularly interested in this chapter and in this focus in the book is that we do tend to spend a lot of time talking about where we're going with artificial intelligence and machine learning and systems that are all-inclusive. And yet there are still many of us who are basically individual practitioners who are dealing with parties in a relatively traditional environment, but we're doing it now with creating a virtual environment instead of an at-the-table environment, but we're still operating as practitioners in much the same way we did before the pandemic and before technology came along. And so the question that I tried to raise with Noam was, so what? If that's the case, what does it mean for the practitioner to be using technology? So I'm going to turn it over at this point to Noam and ask him to get us started by talking a little bit about the chapter on ODR and mediation.
Thank you, and welcome to Cyber Week, everybody. And I'm so happy to be at yet another Cyber Week. Can you see my screen? Excellent. Thank you. So So this was a bit of a challenge, which is interesting because I mean the chapter is written. So what's the challenge here? And the challenge was finding something to say that goes somewhat beyond what we wrote in that chapter for a couple of reasons. One of them being that we essentially had a session on online mediation and ODR in the COVID era at last year's Cyber Week. And as I started preparing for this session today, I found that a lot of what I was preparing was in essence repeating a lot of that. And I really didn't want to do that. If anyone's interested in that, on my YouTube channel, you can find the recording of that. It's called the Online Mediation Surge from last year's Cyber Week. So I tried to think about what we can add, both taking the chapter that Dan and I wrote into consideration and also sort of a bigger picture. Which is why on the slide I wrote that this is a talk that I'm giving, and for the good bits, Dan Rainey, which I mean that I may go off topic and voice some silly projections or silly opinions, and I don't want to drag down with me. But the really solid parts of what I will be talking about are a part of our joint chapter, and it's such a privilege to work on anything with Dan in this chapter. This chapter was a pleasure to work on. It was also very tricky to work on in the sense that we did a really good job of getting it in and getting it in on time, as opposed to the other chapter I wrote in this book. I'm glad that Dan's screen is blacked out right now, so he can't roll his eyes at the latest author on record. But this chapter we had, relatively on time, and it was fully prepared at the beginning of March 2020. Literally, I think the last draft the last iteration of the first draft was March 10th, 2020. And then of course we had to rewrite it substantially a few months in. So as I was thinking about what can we talk about that brings both the chapter together and also adds to that and takes into account the topic of today, which is, I saw it listed as ODR's impact on practice fields. So what is the impact of ODR? What is the impact of ODR on the field of mediation? So I realized there are essentially three players, and this is not a very good diagram for showing it, but in the chapter, Dan and I discussed the question of what is online mediation's role in the broader scheme of ODR, and sort of expanding that theme for what I sort of made up to be the theme of today. It's impact on the broader area of mediation. So we have three sort of areas that overlap in part, not as on this diagram, but overlap in part. You have online mediation that has that it's a part of the ODR world, and it is part of the mediation world. What are the mutual impacts of these three areas? So we start off in the chapter by mapping out online mediation's sort of special place within ODR, or ODR as a field. And if you look at this chapter within the first edition of the book, so roughly from the point of time at which Ethan and others started to discuss ODR until the first volume came out in 2011. So while online mediation is a pretty significant focal point of ODR, and you do have many of the early experiments in online dispute resolution were essentially mediation experiments or involved mediation. And many of in our first mapping out of ODR websites, service providers, ODR was online mediation was very significantly offered. However, ODR's impact and online mediation's impact on the broader world of mediation was negligible at best. It would be an overstatement to say negligible. I think we'd all agree, including those of us who practiced mediation and online mediation at once in that period, there was no impact on the broader field. The broader field of traditional mediation, wasn't buying it, wasn't interested in it, and certainly no insights from ODR or online mediation traveled inwards to the broader field of mediation. And while there was a lot of online mediation activity in these years, it wasn't affecting the broader field. And the second, the last decade was a really interesting one in that sense. And while these, again, this is an imperfect diagram, but this was the decade in which individual practitioners started to move a part of their practice online, increasingly throughout the decade. And when I say throughout this decade, I'm saying pre-COVID. So we saw individual practitioners coming online. We saw a shift to video happen from the text-based previous decade to the video-based, certainly from 2015 sort of and on, which really convinced more and more people that you could replicate mediation in this modality. And so online mediation started to have a greater impact on the field of mediation, of traditional mediation. And it was also becoming mainstreamed by dispute resolution, traditional dispute resolution and mediation organizations, whether it's the DR section of the ABA, or whether ACR or other organizations who started looking at this more and more and talking about it more and more in such a way that it became more just a word that all practitioners started to hear and something to consider that all practitioners started to consider. As far as online mediation impact on the field of ODR broader, I'd actually say that it seems that its impact diminished. It played less of a role in the broader field of ODR as it became more clear that different areas in ODR started to emerge and solidly become identifiable. So there were the replication processes such as online mediation, online negotiation, online arbitration, ombuds, and some of the things that we'll be talking about in this panel. But other fields that had always existed sort of became much more identifiable. Systems ODR, which had been, it had been a part of the ODR world, including the eBay system, but it became much more of a focal area in looking at ODR more generally. The rise in artificial intelligence and its role in ODR, particularly in negotiation, but also in other areas, was far more noticeable in this period. And different practitioners, both individual and service providers, began to get into that. There's a demonstration of some of that that Smart Settle is putting on this week in Cyber Week. And finally, through the latter half of this decade, the rise in court ODR, which might be, the picture is of a British courthouse for sale because they physically sold off 50% of their courthouses in their shift to online proceedings. And while that's perhaps a form of systems ODR, it's received sort of its own space in the ODR, and who knows what else is out there in development. And this is all my way of saying that the overall role of online mediation as the centerpiece of ODR has retreated, and that's probably a good thing for the ODR field in general. Bernie Mayer in Beyond Neutrality spoke for years about how the identification of the field of ADR specifically, particularly with mediation, hasn't done it a good service. And I thought that to be true of ODR as well. When we jump to the end of the decade and to the beginning of the new decade, this is an infographic put together by Nikki Borowski from JAMS in New York and now Global. And sort of this whole notion of virtual ADR or online mediation, 5 stages, starting from denial and ending with acceptance and who knows, maybe preference. And those of us who have been in the game for a while know that that the first stage was actually the first 25 years, more or less. And then the whole stages 2 to 5 were, depending on where you are in the world, happened within 2 to 3 weeks, somewhere in this period of time. And I'm not going to talk about the whole preference. I'm sure others will be speaking about that during this week. But I do want to show that the map has really, really changed. when currently in the world, most mediation is online. I mean, sure, you know, on an individual country area practitioner basis, some people are meeting in rooms, but if you look at like the large mass of mediation over the last 2 years, it's nearly entirely online. And at least on the perception level, online mediation is playing a huge role in how people perceive ODR to be. In other words, so many people now who speak about ODR, what they're really speaking about is the online practice of mediation that we've all been forced into in the COVID period. Now, that's not necessarily a correct portrayal of ODR, but I'd suggest that it is, for better or for worse, it is sort of a perceptual model of how people look at the field now, whether that's precise or not. So in this period, it's really hard to separate. When I think of the title of the panel of ODR's impact on mediation, I found it really hard to distinguish between ODR's impact on mediation right now and COVID's impact on mediation. And I think that's really important to consider, not only from the perspective of how things will be in the new normal, but sort of it's a little too early to map out the field as it will be, let's say, in a month or 2 or 5 or a year, and say, well, you know, things have changed in one way or another. It's a little too early for that now. And I'm sure that there will be a session or 2 on that at next year's Cyber Week. Wow, the 24th. I will note that it's really, really interesting to notice that with everybody jumping online to conduct online mediation and online arbitration, online ombuds, online negotiation, online everything, we're starting to hear a pushback from inside the ODR field saying, that's not real ODR, or ODR is far beyond that. And I know that we're going to have, I'm sure there will be some conversations maybe over the course of this week in which that will arise. I just found it really, really interesting, and considering sort of the ebb and flow between those 3 areas now, how when 3 years ago, we as a field, sort of the ODR field, was just thrilled with every mediator who said, well, I do part of my mediations online, and that would be a cause for celebration. We're hearing a lot more pushback as to what that means. And I recognize that, you know, not the concern, which is ODR is so much beyond that. And there's some concern with mishmashing and with dilution. And while I'm ordinarily really very much of a purist, I love to get into definitions and say X is X and Y is Y. I'm not sure that that serves us well at this current moment, but I'll save that for further arguments. Looking at the bright side, with all mediators jumping online during this period, I think that ODR has had a lot of impact on mediation, and mediation has now, this influx has served ODR well. It's expanded ODR's reach. It's increased everybody's abilities with technology. Everybody has heard of ODR, whether they've heard of the right ODR or not. Most people continue to think that ODR is a lot of online mediation, which will impact developments in this field. And we've had such a huge natural experiment that we don't know much about the outcomes, Les. And I'm really fascinated by what we're going to see of that. And all that leaves us in a situation where the argument about whether this can work and promoting ODR, that's a thing of the past. And now it's a question of, how do we do this better? How do we do this best? And how can we, and there are many more creative minds in the game. And I think where I'll make one more comment about this and then end is that the really big question for looking at the field of mediation, and not necessarily the field of ODR, but looking for ODR's impact on mediation. I think that a really big question lies not in, are mediators going to stay online or not? You know, I can't get back to the room, or all my mediations are going to stay online, and those discussions that are going on now all over the place. I don't think that that's the most interesting. I think that the most interesting question is the bigger picture question of, Are we just at the starting point of technological adaptation, adopting and adaptation of all of the processes we're about to talk about today? Or is this the ending point? In other words, is the ending point sort of, yeah, we did it by Zoom and we loved it, so we're going to keep doing it by Zoom? Or, yeah, we did it by Zoom, we hated it, or it worked in a pinch and now we're glad to get back into the room? Or will it really be more of a, we've experimented with technology in our traditional processes, and now we're going to be open to different experimenting with technology in our traditional processes. And that, if the answer to that is that there is much more openness to that, then that's when ODR is really going to start impacting the traditional fields of mediation and other fields. This picture is just I can't help it, but a plug for a work in progress on Star Wars and conflict resolution. But here you see, a negotiation around a table in which technology is very much a part of the room. And I think one litmus test for that, are we adopting more, are we ready to work more with technology, is whether we see increased use of technology in traditional mediation rooms. In 2018, Alice and Carol and I wrote a paper in which we identified the technology currently being used as in mediation rooms. And it didn't take us very long to identify it because it was at most, a legal pad or a whiteboard. And these were very, very technology bereft processes. And I wonder, one sign that technology is becoming a part of mediation practice writ large, which will expand the focus of the ODR field as well, is whether we see more tech in the room. I'm going to stop now, and I'll just invite quickly, Dan, some of this is what we wrote about and some of this isn't. Would you like to choose an interesting corner of that and say something better than I did?
Oh, I doubt that I'll say anything better than you did, but I do have a couple of observations. And thank you, Noam, for taking the lead on presenting the issues in the chapter. The first thing I would say is that it strikes me that the borrowing of Kubler-Ross's on death and dying framework for the responses to the forced use of technology is an appropriate one, because I think, I doubt that anybody would argue very much that the old way of doing things is completely dead. We may go back to doing a lot of face-to-face work, et cetera, but we're not ever going to go back to where we were 20 years ago, 15 years ago, even 5 years ago. So I think that it is an on death and dying process, and I think that's pretty appropriate. In terms of definitions, I'm very comfortable with chaos. And so I don't mind the fact that there are several definitions of ODR out there, and mine is a very liberal one. And the reason I say it's liberal in the sense of being broad, the thing that I would point to is perhaps the largest difference that's overt about the practice of mediation before and after the COVID ground zero explosion, is that we started affecting the practice of mediation the moment we started using desktop computers, whether they were connected to the internet or not. I talk about this a lot when I talk about ethics, but we started affecting the practice way back then, but nobody talked about it as an impact. What's happened as a result of COVID and everybody going online, everybody being forced to use technology, is now the idea of talking about what the impact is, what's different, what changed, what is our responsibility, all those questions that we should have been asking generally, in my opinion, for the last 25 years, we're asking. And I see that as a very positive development. And Noam, I don't know whether you would agree with that or not.
I think all I have to add is yes, and a much better way of putting that than I did. When I talked about sort of nil impact or negligible impact, of course. I mean, I can't imagine working as a mediator without use, let's say, of my PC 20 years ago. Like, why would I? And so many of us did. But again, the impact wasn't as visible and it wasn't as felt. And so we didn't talk about it as much, even though it was there. And certainly in the background, providing so many of those conveniences and efficiencies that were originally portrayed as the assistance that the fourth party could provide the third party. In Ethan's and in Colin's early writing on this, sure, it was doing it back then, even before it came online and started doing a lot more of that. And as you say, it wasn't talked about, spotlighted, celebrated.
What we're going to do for questions is to hold everything until the very end. If you have a question, stick it in the chat and I'll try to pick it up later. And we'll also have a chance to just ask questions directly toward the end. But let's hold everything until we've had the three presentations. We'll do a very sort of rocky transition here into negotiation. Michael, I'll again ask you to do a quick introduction of yourself on the front end, and then take it away and talk to us about negotiation.
All right, thank you, Daniel. And first off, I'm really honored to be part of this kickoff event for Cyber Week. And it's really a privilege for me to be surrounded by those of you who are on screen here. So thank you for that invitation. In terms of a little bit about me, I was first trained as a mediator 49 years ago. You know, I was in diapers and I'm still young, right? So after law school, I became a party advocate, and in that role, I was a negotiator in collective bargaining disputes, as well as to negotiate resolution of legal matters. I had the advocacy beaten out of me by the Federal Mediation and Conciliation Service, became a full-time neutral in 1993, and director of the FMCS Mediation Technology Services, which is where I met Colin. And from there, became part of the ADR group at the National Mediation Board, which is where I met Dan. So two very fortuitous encounters and wonderful people who are part of this session today. I am currently, and since 2010, I've been the director of ADR, actually the director of collaboration and alternative dispute resolution at the Federal Labor Relations Authority. We manage labor relations for federal government agencies and the 1.2 million federal employees who are part of collective bargaining units. I'm also the settlement official in the Office of Administrative Law Judges there. I've been adjunct teaching labor relations, ODR, and negotiations at several universities. And so that's just a little bit about me. I was invited to write the chapter on negotiation for the second edition of the ODR Theory and Practice book. And in that chapter, I define negotiation as a voluntary method that people use to strategically engage each other about things we care about. And my view of negotiations is that it's really the fabric as well as the heart and the soul of the way that we use ODR. And by the way, I've done something radical here this morning, or at least where I am this morning. I'm actually not using PowerPoint or a presentation deck, and I'll just try to speak for about 10 or so minutes. The way that negotiators define success and the behaviors that they engage in to achieve success, I believe is largely driven by the type of relationship they want with each other at the conclusion of negotiations. And that in turn determines the way that negotiators most effectively utilize ODR in negotiations. In a distributive model of negotiations, many of you know that what we do is we adopt a position, which is our preferred outcome, and the degree to which we are successful is determined by how close we get to that position. That form of negotiation is normally a zero-sum game filled with a healthy dose of competition and also some cooperation. It's okay to make the other party lose when you're engaging in distributive negotiations. if you need to do so in order for you to win. And this type of negotiation can be most useful between parties who have no ongoing relationship or whose future relationship with each other is relatively unimportant. Think of rear-end car accident or an eBay sale between people who have never met and probably never will. For them, bargaining is a transactional event, and ADR or ODR, these are tools for resolving disputes rather than solving problems that gave rise to those disputes. Now, there's a different kind of negotiator, and that's one who uses an integrative model where they consciously avoid adopting positions. They explore options that best satisfy both parties or all parties' needs. They often are referred to as interests. And in this form of negotiation, it's viewed as an opportunity to expand the pie so that everyone can be more successful. This type of negotiation is most useful when parties are perceived, or when parties perceive that there's significant value in maintaining and enhancing their relationship with each other. Think of business partners, nations with common borders or mutual security agreements, or negotiations between entities in a multi-tiered enterprise, or a labor management collective bargaining matter, or a divorce that involves young children. So just like there's one form of negotiation that's not best for all relationships, neither is one form of ADR or ODR. ADR, in my view, is a set of process tools that we as third-party neutrals use to help negotiators be more successful, whether it's distributive negotiators or integrative negotiators, or a blended version of the two. Some ADR models and ADR practitioners are best suited to effectively and efficiently resolve transactional disputes like the car accident situation or an eBay transaction. The underlying problem, though, of drunk driving or unscrupulous eBay sellers or buyers is not necessarily solved through distributive negotiations, but the dispute that gave rise to the transaction, it's over. Other dispute resolution models and practitioners might be best suited to helping integrative negotiators expand the pie, to improve at least, maintain, if not improve, constructive relationships, and achieve outcomes that satisfy stakeholders' key interests. Integrative negotiators might be trying to solve the problem of drunk driving or the problem of unscrupulous eBay sellers. Different ADR models and practitioners and their competencies are required to support this integrative model of negotiations compared to the skill sets required for distributive models. I believe ODR in negotiations can be distinguished and measured in a similar way. For example, the type of ODR that Colin Rule and his team developed at eBay, where they enabled low-cost virtual distributive negotiations to resolve transactional disputes. It's a brilliant way that was not previously achieved. But if two nation states want to preserve and enhance a cooperative yet competitive relationship as they renegotiate their joint protection treaty, they would probably use something other than the ODR tools used in eBay. So in chapter 14, I describe ODR as a collection of software, online services, interactive technology, AI, all related to minimizing barriers and enhancing opportunities for negotiators to be successful. So this is sort of looking at ODR from a lens of a negotiator, as opposed to some of the other lenses, some of which Noam was describing. The most important feature, I believe, that distinguishes ODR from everything else for negotiators is the way that negotiators and third-party neutrals use the software and the online services and the AI and the technology-related processes, or whatever it is that we're calling ODR. Because I think different people are calling ODR or different things ODR. So again, in my view, this makes ODR a rapidly evolving concept with really fuzzy edges, much like many of us are still trying to define what mediation means. And even that is very difficult. So due to the variety of negotiation styles and ADR methods and the pace at which technology changes, the connectors between ODR and negotiation, I think, also grow and change rapidly. So rather than becoming too attached to our favorite definition of ODR or our favorite ODR tool, as a negotiator, I suggest that we focus on the functional criteria that cause ODR tools to add value and minimize harm in the process and outcome of negotiations. Today, integrative negotiators use ODR to schedule interactions, to generate and organize ideas, to safeguard and share files, to share screens. They use ODR to solve problems, to offer and respond to proposals, to work towards agreement, to overcome barriers to agreement, to make decisions, and sometimes to realize it's best to not make decisions, and sometimes it's best to not resolve the dispute. Because sometimes problem solving is more important than dispute resolution. They use ODR to manage implementation and relationships. Negotiators use ODR for purpose of surveying constituents and stakeholders. And sure, they use it to engage remotely with video and audio and data conferencing. And on and on and on. This list is certainly not all-inclusive. And it'll continue to change in response to the evolving goals and barriers inherent in negotiations. Now, like any powerful tool, we should only pull ODR out of our toolbox when it's the best tool for the job. Some believe that it's best and it's only linked to when you're engaging remotely or virtually. I found ODR tools to be extremely useful even when parties are in the same room at the same time. And a lot of people don't even think of ODR being applied that way. But I found negotiators have found great value in using it that way. I suggest to negotiators that they generally consider introducing technology to negotiation in this ADR mix when two conditions are met. First, when it's highly unlikely to cause harm, first and foremost, and second, when it appears likely to add meaningful value to the party's process or their outcome. So in the second section of my chapter in the book that we're here to celebrate, I discuss when distributive and integrative negotiators should consider using ODR, especially given this rapid increase in our virtual and remote engagement due to the pandemic and hopefully soon to be post-pandemic conditions. I discuss how for decades some of us have been using ODR tools to overcome barriers of time, place, cost, and process long before the pandemic drove so many others into our space. I discuss how our ODR can even enhance synchronous in-person negotiations and help overcome the self-limiting negotiation behaviors that occur both in person and online, such as evaluation apprehension and production blocking. And I even define what those terms are and discuss them a little bit. I also offer a multi-step analytical tool that you might use to help determine whether to use ODR in upcoming negotiations. or you might use to help your clients and those whom you work with to do the same. In the next section of my chapter, I discuss, first of all, some security recommendations when considering the use of ODR in negotiations. I think that's really important and oftentimes overlooked and pushed to the background. I also offer some examples of how negotiators actually use various types of ODR, such as in synchronous and asynchronous online workspaces for dispute resolution, and collaboration and complaint handling, and how really there's not much difference between those three from the standpoint of providers and neutral practitioners. The chapter also contains examples of how negotiators use visual and double-blind bidding ODR tools, video conferencing, electronic charting, mind mapping, and how we help negotiators draft, edit, view, and e-sign their negotiated agreements online. And I then offer several detailed illustrations of how in public sector we use ODR. And I give examples at the Federal Mediation and Conciliation Service and the National Mediation Board and elsewhere. Oh, I forgot to mention that I also spend time discussing what I call a full service ODR platform. And that enables negotiators, this is really cool, it enables them to initiate and schedule, to bill and for practitioners to bill and get payment for and engage in video, text, audio, screen sharing, secure document exchange, and apply this tool to both integrative as well as distributive modalities, and to distributive and conflictive modalities for single parties, for multi-parties, in one-on-one and even team negotiations. And it's been used for so many different things. It automatically morphs from, it senses whether you're doing some kind of interpersonal engagement or intra-organizational engagement, or even international matters, and senses and adapts to these cultural differences that we need to engage with. Above all, it does no harm. And above all, it's not real. There is no such thing. We may all like envision, oh, this is what ODR can become. This might be the holy grail of ODR, but in reality, there is no such thing yet. I'll be first in line if it becomes available tomorrow, but until then, we're going to still be in our developmental phase, even though we've been at it for about 40 years now, in terms of development of ODR. In section 4 of my chapter, I discuss the development and the origins of ODR. A lot of people, even in our field, they're not familiar with some of the visionaries in the 1980s and the 1990s and the early 2000s who brought concepts of ODR to life, even before the term ODR was coined. And in section 5, I express concerns about trajectory into the future, including differential access to ODR tools. If negotiators don't have opportunity to have access to these tools and the competencies to effectively use them, we need to seriously think about whether ODR is affecting the playing field of negotiations. Also, the potential conflicts of interest between ODR developers, providers, users, and theorists. That's very real. And we need to I think, consciously be thinking through how we're going to prevent harm from resulting. Of course, the resistance from the traditional ADR community and the impact of cultural blindness and the increasingly polarized world around us. All these, I think, have an impact on how ODR for negotiators develops in the future. But I also take a more positive look at the potential for online engagement to transition from dispute resolution to conflict management, and the promise of ODR improving access to justice, because we oftentimes negotiate the solutions within the justice field, and some other matters too. So with that, that's sort of chapter 14 of negotiation in ODR. And Daniel, thank you for the opportunity to share that.
Well, thank you, Michael. I appreciate it. It's there's a lot of information in that chapter. Put it that way. It's well worth a read. And I had a couple of questions, but I'm going to bite my tongue and hold on to them until after we give Frank and his colleagues a chance to weigh in on ombudsmanship. And if I understood correctly, Frank Fowley, you were going to be the lead on this. So I'll ask you if you would to introduce yourself and your colleagues and tell us about your take on ODR and ombudsmanship.
Well, you're saying, if you understand correctly, and I'm hearing, Frank, I just volunteered you. So most everybody here knows me, and some wish they didn't. I'm Frank Fowley. I've been an ombuds practitioner on and off for about 20 plus years. I'm in the dawn of the day in Richmond, British Columbia. I'm a member of NCTDR, hold a doc in conflict resolution. And I want to introduce my two fantastic colleagues, Herb Way, who's the ombuds at ICANN, which is a job that I had once upon a time, and the amazing Dr. Claire Fowler from Eugene, Oregon, who I met many, many years ago when she was at the Strauss Institute at Pepperdine University, and is now with Mediate.com and runs their amazing case management platform. So the discussion today will be fairly open because both my colleagues will take the floor, and they'll have muted myself. And at the end, I'd like to spend a couple of minutes talking about a transition that I've been looking at in the world that I'm now in as a member of the Immigration and Refugee Board of Canada, which is Canada's largest administrative tribunal, and due to COVID has gone entirely to an ODR way of doing business. So this chapter was kind of an interesting one, and I won't be kind of just regurgitating what you can read. And I know everybody here has read the chapter. It's riveting, it's entertaining, it's poignant. There's some mystery in it, but it was an interesting chapter to write, mostly because there was a lot of apathy from the colleagues in the profession. So it began as a reflective look on the chapter that was written 10 years ago, and to see what's changed, what's grown, what's improved, what's gotten worse, what's stagnant. And the one thing that surprised me was the absolute sort of lack of cooperation from groups like the Ombuds Association and the Forum of Canadian Ombudsmen. We put together a survey on SurveyMonkey, wanted to distribute it to colleagues and have them tell us what's going on in their practice, and then take that amount of data and look at what it was going on 10 years ago and see what's changed. And of course, we all know that since the chapter was written and the book was published, the world has changed the way that business is conducted, and probably the answers that we would have had 20 months ago would be entirely different than what they would be today. So we started off with a very small pool of responses that probably weren't statistically significant enough to draw any conclusions. There were some qualitative things that we could learn, and I think those will have changed again. Found that basic online tools were used mostly in terms of complaint taking. People could log in, create their complaint online, submit it online, and email was used as a principal form of communication between the ombuds and the parties, or between the parties. That's probably changed a little bit. I think we'll have seen a lot more development in organizations to do things online, because people just can't sort of walk into a government office or an institution and meet people anymore. So things will have changed in that way. One thing that the chapter did permit was the opportunity to speak to two colleagues who are absolute leaders in the work that they do. Claire, in terms of creating case management opportunities and that are developed specifically for the user, absolute leader in the field. And Herb, who's one of her clients and also is in the first ombuds office to be truly an ODR office, because it is worldwide, 24-hour time zone service, and obviously can't meet people face to face. So they contributed, and I won't steal their thunder, but just to say that both of them, absolute leaders in the field, it was a great pleasure to have them allow me to bring them into the writing of the chapter, and I'll turn it over to Claire and then Herb.
Thank you very much, Dr. Fowley. So I think what would be helpful is if I just share a couple of thoughts about our approach to online dispute resolution and the interplay with the ombuds world as a foundation, and then I'm going to hand it over to my good friend Herb. So since it was pretty early, I had to put together some kind of a PowerPoint, but it's only a couple of slides, don't worry. So as we are thinking about moving all of our offices into an online environment, I felt like about 1.5 years ago, it was as if we had jumped onto a bike for the very first time. And for the majority of us, it wasn't really a planned transition, probably not even something that we were looking forward to doing. And for quite a few offices, at least the offices that we've been working with at mediate.com, it was a little bumpy at first. In other words, we didn't know what we didn't know. And so I think the first half of that time in quarantine, the majority of offices were running into, oh, I didn't realize that I had to think about protecting data during an intake. And I didn't know that I had to be cognizant of how much time I'm storing this data, and then also be transparent about that with the visitors coming to the office. And we also definitely had a few scraped knees. For instance, people saying, oh, I put together a report and accidentally revealed personally identifying information on it. Or I was too transparent with my intake, or I asked too many questions, or I didn't ask enough questions. And so we ran into a few trees, as I say. And I think that now, as a majority of offices have been using ODR skills for the last 1.5 years, I think it's a great time for all of us to take a step back and talk about improving our technique, right? It's time to become the Lance Armstrong, I guess, of ODR. And so I really appreciate all the work that Frank and Herb put into this chapter, just thinking about what are the best ways to capture data. And I'm not surprised that Frank was involved in this. I remember 17 years ago when you did the presentation at the IOA conference with John Zinsser, and it was about how to justify an ombuds office, right? I might be a little bit off on the dates, but that presentation has always stuck with me, because essentially what he was doing was taking the qualitative soft skills that we can use in an ombuds office, those magical moments where you're setting up a safe place for visitors to feel heard and validated, and you're taking that qualitative moment and quantifying it. And I was impressed at how much you were able to streamline the process, understand all of the different pieces. And once you could do that, then you created a deliverable essentially for every one of those steps. So that's how I've been trying to think about setting up dispute resolution for ombuds offices, right? Trying to take that qualitative moment and quantify it. And so these were the different areas, at least at mediate.com, that we've been thinking about case management, right? How can we look at every one of those important steps when we're meeting with visitors and make sure that we're doing the best job we can, right? Noam, I appreciate what you said, that a lot of our dispute resolution might not have been as thoroughly thought through initially as for a lot of offices as we would have liked. A lot of it was just simply a knee-jerk reaction to COVID. And so at least at Mediate, what we've been trying to do is take these last 6 months especially and work with offices and say, okay, we're not in as much of a panic now. Now let's take a step back and think about how can we improve our data collection and our data storage and make sure that it's not just a clunky, fill the gaps process, but that this does feel like a connected workflow. So I'm not going to go through all of these, but I'm just going to use intake as an example. So when we are working with clients and thinking about what data we can ask for, we want to break this into a few different pieces. It's the initial, how are we retrieving the data from them? Does that feel like it is a connected process, or is it a one-off? And whenever it feels like a connected process, the key here is that then the client feels a little bit safer, right? They don't feel like we're asking some, I don't know, Nigerian prince to collect their data, but it feels like it's us, right? It feels safe if it's a connected process. In other words, Herb has an intake form that's living right on his website that's clearly cohesive. And when clients input their data, they know that it's going to a safe place. But then technologically, it's also a little bit safer because simply then we don't have to transfer data back and forth to as many points. So again, this is just one example of many where I think it's really our duty to look at all of the different places that our data is transferred to and think about how can we minimize that and kind of squish it into one format, into one module. So instead of having lots of one-offs, like here's QuickBooks and here's Dropbox and here's all of these different things that I'm doing with my data, how can we consolidate that as much as possible? Again, it's simpler for our clients and it's safer for their data. And the other piece I wanted to share here is that I really appreciate, Frank, I think it was when we were initially talking about setting up that form, was that interplay between developing rapport and developing reports. In other words, we want to make sure that the client or that the visitor feels like their data is being respected and taken care of that entire time. But we also want to make sure that there are a couple of locks on the door, so to speak, that we're not just wishy-washy and everybody can come in and we'll do whatever we want with their data, but instead be a little bit transparent with what we're doing and letting clients know, here's how we've thought through the process. Here's how much time we're going to be storing your data. Here are the demographics that we're going to store. Here's how we're going to remove the personally identifying information to make sure that they feel safe, but we also have enough data at the end of the day to turn the qualitative into quantitative, to have some kind of reports to explain what we've been doing the last year. And anyway, so that was the piece that I wanted to share, that while we are doing all of this to make sure that the data is safe, that we also have to remember what is the experience like for the visitors so that they feel welcomed and respected through the process as well. All right, those were my pieces. Off to you, Herb.
Thank you, Claire. And I apologize if there's a bit of background noise. The piano tuner just showed up about a minute ago, and he's in the next room with my wife tuning
It's
one
lovely.
of the pianos. So I wasn't sure if I was going to speak first or if Claire was going to speak first after Frank. So I was just going to say I will let Claire talk about all the technical stuff. But the point I will make as a practitioner is that in the last 18 to 20 months, any other practitioners in the ombuds world or in the dispute resolution world that I've spoken to, I've started the introduction with "Welcome to my world," because I recall going to my first IOA and FCO Forum of Canadian Ombuds meetings, frequently accompanying Frank, 15, 18 years ago, and mentioning that, and even as recently as 5, 6 years ago, mentioning that, the majority of my work is done online and that I use email, and the recoil in horror that I would discuss ombuds issues with a client or part of my community by email was just a violation of every possible ombudsing rule regarding confidentiality and trust and everything like that. But my community uses emails, so they trust, they acknowledge that there's a risk, and they trust that that the communications we have will remain as secure as possible. Hence, the work that Claire does in ensuring that that the platform and the technology can be as safe as possible within reasonable expectation. And I often feel sorry for Claire because she has to deal with my organization, which runs the internet, basically, the DNS system, and writes all the protocol and rules and policy for the servers and the routers and the IP addresses and everything else on the internet. So they know about internet security and internet, security certificates for websites and so on and so forth. And I recall going back a few years when I moved the platform, the intake platform to Mediate, the hoops that her group had to jump through to satisfy all of the security and the technology issues that my IT department were throwing at her, and kudos to them. But it brings us to the other point I want to make, is that you have to make sure that your platform and the work you're doing is secure, and not just technology wise, but also legally. That, for instance, the European data law protection laws and some of the American laws. My headquarters is in California, so there are California laws that must be respected when it comes to online dispute resolution. You have to keep all of that in mind. But I think the biggest thing that when it comes to online dispute resolution, as far as I'm concerned, is having a community and having clients that trust the process and trust the system and trust the technology. And a big part of that is communicating the security and the safety of the environment, so that your people, and I had the advantage of having a group of clients, a community that trusted the internet and trusted the use of emails and online forms. But if you're in a college environment, or if you're in a corporate environment or community environment where people are not frequent or full-time users of the internet, that messaging is probably the most critical part of online dispute resolution, and getting them comfortable to be able to use it. So that's it for me. I apologize, no PowerPoints. And I guess maybe back to the moderator for question period or whatever is next. Thank you.
Thank you guys very much. We appreciate that. I do have, we got about 7 or 8 minutes left for questions. So I'm going to do a quick lightning round here and ask that we get quick responses to the quick questions that I'm going to ask. I'll go to you, Noam, first, if you don't mind. One of the changes that I think we've all seen since the early days of online dispute resolution is a slight variation in the definition of the fourth party, which Ethan and Janet gave us back in 2000. I think when they, and I've heard Ethan say this, that when they first coined the term fourth party, they were thinking in a relatively limited term about the impact that any technology has when you start using it in a dispute resolution process. And we've come to really think about it more as sort of AI and algorithms and sort of taking over the process. Do you see, as mediators, as practitioners, do you see the fourth party change, the algorithms and AI, making a huge difference in the short term for individual practitioners?
In a nutshell, not in the short terms. In terms of what you see mediators using in terms of technology right now is very much in the paradigm of the fourth party as the third party's best buddy who's fun to be with. And that is where technology is at. It supports communication is how everyone is using it nowadays. And at the edges, you see software starting to support in other ways, such as ADR notables work on note taking. So again, it's supporting the third party in practice of traditional or even relatively online mediation. It is hard to find people talking about things in the realm of AI, far less actually developing it.
Thank you. Michael, quick one for you, another lightning round question. One of the definitions that I've worked with ODR, as I said, it's sort of a liberal definition, is that if you do any of the functions that are central to dispute resolution, you probably belong in the ODR tent somewhere. You talked about functions. Could you identify very quickly what you think for you as a practitioner have been the most important functions that you've been able to fulfill using technology?
The most important functions, I do almost all my work, using technology. So I would have a hard time just finding one that's most important. I think that it's the sum of the whole that probably makes it the more important rather than any one of them. So to me, that would be what's most important, is the collection of them used together and appropriately that is most important. Sure, right now, everybody's getting online and doing the video engagement, and but that's not sort of like the most important way that we all engage all the time. And most of the video is so bad that, unlike your face right now, Dan, where I can see facial expressions and I can tell, I can guess that there's some eye contact going on, and I can guess that, through nonverbal, that there is a level of communication there. But most video just unfortunately is not adequate to do that, and is not used appropriately to do that, and not used by people who are trained to do that. So, and most of my remarks that I've just made are in light of the distinction between distributive versus integrative negotiators. And I'm talking more about the integrative side. And for distributive side, I'm probably not the voice of expertise.
Fair enough. Thank you, sir. Frank, or anybody who wants to jump in on this, a couple of questions I had for you, but the one that really sort of struck me is that there's always been, as you have said, and Frank mentioned this years ago when he was the ombudsman for ICANN, this sort of push and pull between ease of access and security. How do you address that issue with the clients who come to you? How do you deal with making them feel that it's okay to use email, which I think most people would say you would recoil at, as you said? How do you do that? How do you make that work? And how important is it to meet the client where they are as opposed to giving them best practice, in your opinion?
So I'm going to preface that by saying that this morning on our national news network, the lead story and lead interviews were about the province of Newfoundland and Labrador, where the entire health system, IT, had been the victim of a ransomware attack. So this is a government entity dealing with people's health records, scheduling, surgeries, and basically they were saying, today we're going paper-based, and unless you've got an emergency, don't come to the hospital. So there is no guarantee of security. Even the best and tightest systems in the world are somewhat at risk. So I don't see people coming and really asking that question. Is my correspondence with you secure? Most people in today's world, especially in the world that Herb is in, there's just kind of a general acceptance of that's the way the work is done. There's sort of, and Herb mentioned this, there's very interesting overlays on national, continental, and regional data protection and information privacy requirements, those sorts of things. So Herb could be dealing with someone, he's in Ontario, so the federal PIPEDA, Protection of Personal Information and Electronic Documents Act, applies to him, but he may be dealing with someone who's writing him from Europe, so the GDRP European regulations apply, and he's dealing with a server that Claire set up for him in Eugene, Oregon. And so there are national and state laws that would apply there. So there's this panoply of regulation. And it gets harder to define when you start working in that international space. If you're in an organization, I've spent a few years as an ombuds in the UN system. If you're in that system and it's hermeneutic, people have a lot of confidence in it, of course, because they work in that system every day. I don't think it's really something that people have front of or top of mind. Is anybody going to hack your server to get my data and see my complaint? I don't think I've ever had anybody actually raise that as a question.
Thank you. Well, we're out of time. Unfortunately, I wish we could go on for a while, but let me thank all of you very much for the presentations. They were very interesting, and I'm sure everybody enjoyed them. And I want to turn it back over to Leah very quickly so that she can, from the center's point of view, wrap us up and get us on to the next thing.
Thank you so much to that panel, to Dan for moderating. Incredibly interesting, both looking backwards and also looking forwards about how ODR has impacted and integrated and infused itself into these three practice areas. I put in the chat how you can access getting a copy of the book at a discounted price, and also a reminder that we're having author panels every day this week. Hopefully you can join us for them and for the rest of Cyber Week.